Hey future attorneys, it's your girl Jamil and welcome back to Jamil's Journey to JD. Today I'm actually going to be taking you guys along with me as I get ready for my oral arguments and even prepare my trial brief. I'm actually going to be showing you a meeting that I had with my professor, and you'll see the transition as I am assigned the plaintiff as my client and actually not in support of her in the beginning, and you'll see my transition evolve as I'm getting ready to essentially represent her and try to get some justice for her in her favor. So you'll see that. You'll also see me with my classmate Claudia as we run through and practice our oral arguments. And then you'll see me actually do my oral arguments towards the end of the video. So if you're ready, make sure you stay tuned and we'll hop right into the video. Hey future attorneys, so I'm actually here with my dean. We're actually going over my trial brief. So I actually had an assignment a few weeks ago about a plaintiff who I am actually representing. She is a student in high school and she got suspended. Long story short, she got suspended because she wore a shirt that had a gun on the front with a red circle striped through it that said, what did it say? It said puns not guns. Puns not guns. And on the back it was a picture of two bears holding hands, and it said bear hugs not arms. And so she was instructed by the principal to take off her shirt. She did not. She actually brought extra shirts to school, handed them out to other students, stood on the picnic table, passed out the shirts to other students, and caused arguably, possibly, potentially, substantial material disruption. And so my job is to argue for the plaintiff, saying that she did not cause material and substantial disruption because she got suspended. She has her scholarship forfeited, or a possibility for any scholarships forfeited, because it reflects on the transcript. And yeah, we want to make sure that she gets that wiped off of her record with an opportunity for her to get scholarship in the future. That sums it up?
That sums it up.
Perfect.
Just getting back to some of the argument, I noticed when you were giving your summary of the case, you mentioned your client standing on picnic tables and causing kind of a little ruckus or whatever in the school. And you didn't really mention my client who was wearing a shirt advocating for peace to keep guns out of school.
Right.
Her First Amendment rights have been violated. After all the shootings and violence in schools, your client who was wearing a shirt advocating for gun control and safety in schools, the principal suspended her.
Right.
You see the difference?
Yes. That was good. Okay. That's a real life teachable moment.
Part of this is forming your professional identity and your philosophy of lawyering and deciding what kind of lawyer you want to be, and what type of cases you want to take, who you want to represent, and how you want to represent them. Understanding the facts and knowing what to stress. Right.
Yeah. That's a good point. Yeah. All right, well, thank you.
Sure, good job.
Thank you. I appreciate all the feedback. This was great. Okay. I appreciate it.
Sure. So, if there's anything else I could help you with, let me know.
Thank you so much, Dean Cohen.
You're welcome. Thank you.
Hey guys, so today I'm actually going to be going over my oral arguments with one of my classmates, Claudia. So I'm just gonna put you guys up and go through my argument. You're gonna see her interrupt me and ask me a few questions. And these are things that we're just trying to simulate so that when we actually go in front of the judge, we're prepared with the questions that need to be asked and also how we plan to structure our argument. So yeah, I'm gonna have you guys say hi to my girl, Claudia.
Hi.
All right, so I'm actually just gonna prop you guys up and then we'll hop right into it. May it please the court. Good morning, Your Honor. My name is Jamil White and I'm here today representing plaintiff Elizabeth Stanton. Your Honor, this case concerns my client who is a high school student who wore a handmade anti-violence gun control t-shirt in support of her AP English presentation. The t-shirt said "Puns, Not Guns" with a picture of a gun depicted with a X crossed through it. On the back of the shirt was a bear holding paws that said "Bear hugs, not arms." Your Honor, my client has been suspended as a result from defendant Principal Lillian Baker, who asserts that my client's suspension is based on a violation of Regulation 22. Your Honor, we are asking that you grant my client summary judgment motion for today, for this case, and we ask that you will allow compensatory damages as well. Your Honor, the case that is controlling authority here is Tinker v. Des Moines. In Tinker v. Des Moines, the United States Supreme Court ruled that it was unconstitutional for schools to censor school speech unless it causes material and substantial disruption or it causes potential material disruption. Your Honor, my client did not cause any substantial material disruption, and her First Amendment rights were violated as a result of her wearing the anti-violence t-shirt in order to promote anti-violence, gun control, and as well as encouraging other students to assert their constitutional rights as well. In the
Counsel, would you agree that she caused a disruption in the math classroom as she was chanting about guns and weaponry?
Your Honor, I would say that my client did not cause any substantial material disruption. Although my client did bring conversation into the math class that was unrelated to math, my client was able to encourage the math class to have conversations around the Second Amendment, as well as the math teacher asserts that the students were able to learn critical thinking skills and the importance of listening as a result of the conversation. The students are not confined to those agreements just because we signed the acknowledgement form, because this is a constitutional right.
For not listening to the principal in the beginning and continuing to disobey the principal after she was specifically told not to continue to wear the shirt and cover it.
Thank you. So in the case in Tinker, it says Tinker asserts as well that it can be hardly argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gates. So students are not confined to just the hours of the lunchroom or the cafeteria or the playing field or the campus during the authorized hours. Students may express controversial subjects, even if it makes others feel uncomfortable. In addition, I would like to speak to Giles, where Giles is most similar to our case where a student purchased a t-shirt at an anti-war rally who had on the front of the shirt is a picture of President George Bush's face wearing a helmet with his head on the body of a chicken that's superimposed. The picture also has 3 lines of cocaine in a martini glass. The United States Court of Appeals for the Second Circuit ruled that the images of drug and alcohol on Giles' t-shirt are not offensive because the images are presented as a part of a political message. As in our case, Elizabeth Stanton is wearing an anti-violence t-shirt as a result of a political message, again in support of her AP English presentation, where she was giving a presentation on gun control using puns and other rhetoric to help get her point across in a lighthearted way. My client
It was only reasonable for her to use or be in that type of environment in that classroom with adult supervision. But in contrast to that, she comes out and she's no longer having any type of supervision when she's chanting the gun remarks in the school atrium. What do you think about that?
My client is a member of SAVE, and SAVE stands for Students Against Violence. I'm sorry, the E escapes my mind. But SAVE consists of students who promote peace, restorative justice, and gun control. SAVE is a student-sanctioned organization on campus that frequently meets in the atrium, and they have impromptu events such as poetry slams, skits, and storytellings. They also have conversations and discussions around gun control as well, and so this isn't something that's completely outside of their norm, and as such as well, I would like to point out that in Hazelwood, Hazelwood says that newspapers are not considered a public forum, and the court defines a public forum as one that school officials retain the right to impose reasonable restrictions on student speech. However, if it is by policy or by practice opened by some segment of the public, such as a student organization. So in our case, the student organization that Hazelwood is alluding to would be, in our case, SAVE. So the student organization is SAVE, and SAVE meets regularly in the atrium, and as such, it is considered a public forum. And with that being the case, the school is not allowed to impose restrictions on student speech. Okay, so yes, Your Honor, we are asking that you again grant our motion for summary judgment and grant our request for compensatory damages for the reasons stated for the reasons that we stated herein. Thank you.
All right, you have 30 seconds left.
Oh, wow.
Nice. Okay. I couldn't stop laughing. Sorry. I couldn't stop when you were like, thank you.
I was like, no.
You're gonna see me laughing throughout. I'm like writing and I start laughing and I'm like
Oh, you're so funny. You're
I
so
got
funny.
nervous. I was like, oh my god, yes.
Yeah.
Good. Always remember actual for material substantial disruption, potential material substantial disruption.
Yes.
Like tongue twister, but
yeah, gotta say it.
Solidify.
Yeah.
I like the emphasis on the substantial. After I asked you the first question, you went nice, like you transitioned back to your argument. You emphasized tinker, and you kept going. The rebuttal was good. When I asked in terms of what Giles was talking about, you went straight to SAVE, and then you used Hazelwood, which was the public forum with student speech. It was a nice connection. I like that. And then I really like your potential argument, specifically when you're using cup as well. So I think you did a really good job.
Oh, thank you. I also would like to take a minute to acknowledge that I really enjoyed working with Claudia on this assignment, particularly because we both had opposite views on how we should feel about what we were assigned. So for example, I was assigned the plaintiff side, aka the student side, and I wholeheartedly wanted to defend the school side. And as you'll see, or as you saw in my clip, when I was going through my conference with my professor, she could tell from my trial brief that although I was on the plaintiff side, I did not convey support of my client, which was the plaintiff. I was using more language that was unfavorable to my client, and the same was for Claudia. So she is on the school side, yet she's also she also wants to defend the plaintiff side. So it was opposite for us. So when we were both getting ready to do our oral arguments, we definitely helped each other out and kind of get the language to frame how we wanted to portray our respective clients, and actually as we're practicing and going back and forth with it. So I just wanted to take a minute to acknowledge that if you are defending or in support of your client, or if you're not in support of your client, which I wasn't, that is absolutely okay. And as you can see, there are other students who feel the same way, and just take a minute to just kind of be in your client's shoes. So something that helped me was actually going back through the record, going back through the cases, and really trying to put myself in my client's shoes to kind of like sympathize with her and figure out how I could support her. And that definitely helped that a lot. So just a tidbit, if you're ever representing someone and you don't necessarily agree with their morals, or what they did, sometimes it's okay to just put that aside and represent them because it's your job to do so. Good morning, future lawyers. So it might not be morning by the time you watch this, but it's my morning, and it's the morning of my oral arguments. So I'm actually getting ready to head into the building. I just wanted to check in with you guys and, of course, show you this process and what it looks like. I actually got permission from my professor and the attorney, aka the judge who's going to be judging, who's going to be presiding over the case for my client, and I actually just wanted to show you guys what an authentic oral argument looks like. So this morning I actually was feeling a little jittery, a little nervous, but I'm just excited to get this done with, so to say. I've been preparing a lot, as you guys have seen from the video, so now it's actually like game day. So yeah, I just wanted to check in with you guys, show you what it looks like, and the next time you guys see me, I'll be in the courtroom. Oh, and actually, speaking of the courtroom, it's actually going to be the classroom, because they're using the room that kind of looks like a courtroom, which is like the moot courtroom. They're actually, another class is in there doing their arguments in there, so we're going to be in a classroom. So that should still be fun. You know, we're still going to be a good experience. And yeah, you guys just stay tuned, and we'll hop right into it.
Good morning, counsel.
Good morning.
All rise. The United States District Court for the District of Connecticut is now in session in the case of Elizabeth Stanton versus Lincoln Heights Board of Education with the Honorable Judge Michaels presiding. You may be seated.
Good morning.
Good morning.
Counsel, if you could introduce yourself and we can get started whenever you're ready.
Thank you. May it please the court. Good morning, Your Honor. My name is Jamil White, and I'm here today representing plaintiff Elizabeth Stanton. Your Honor, she is a high school student who has had her First Amendment right violated when she wore a handmade anti-violent t-shirt as part of her AP English presentation that said "puns, not guns," with a gun crossed out on the front. On the back was a picture of two bears holding paws that says, "Bear hugs, not arms." My client was asked to conceal her shirt by defendant Principal Lillian Baker, who suspended her for violating Regulation 22. The suspension has prohibited my client from obtaining scholarship opportunities. We respectfully ask this court to grant our motion for summary judgment according to Rule 56 of the Federal Rules of Civil Procedure, as there are no genuine disputes to any material facts, and we are entitled to judgment as a matter of law. We ask that you grant our motion for this reason. My client's First Amendment rights were violated because there was no potential or actual substantial material disruption when Elizabeth wore and distributed copies of an anti-violence t-shirt to school.
Counsel, I'm going to stop you there because I'd like to talk about that disruption. There's evidence in the record that while your client was leading and participating in a rally of some sort, spoken word rally in the courtyard area, there was a math class going on nearby that had to stop its lesson and was disrupted for approximately 10 minutes. How can you argue that that's not a substantial disruption?
Your Honor, my client was advocating for a peaceful protest, and although the math class did turn its discussion towards a history lesson, the math teacher has said that the conversation has helped students understand the importance of listening and critical thinking skills. In addition, in the case of Tinker, which is a controlling authority here, there was a classroom that was disrupted, and the court still found in Tinker that it was not substantial material disruption.
So how do we assess what substantial material versus just a little disruption?
So I guess we can point to the cases here that's in the Second Circuit. That is a controlling authority here. So I would like to point to the potential disruption in the case of Giles. Giles is most factually similar to our case here because Giles purchased a t-shirt at an anti-war rally. On the front of the shirt has a large picture of George Bush's face wearing a helmet superimposed on the body of a chicken. The picture depicted 3 lines of cocaine in a martini glass, and the United States Court of Appeals ruled that the images of drugs and alcohol on Giles' shirt are not offensive because images are presented as a part of a political message.
But in terms of the disruption, was there a disruption in Giles that his shirt caused?
Right. So there was a teacher and I believe it was another parent that was offended by the T-shirt that Giles was wearing, and that speaks to more of the potential disruption that Giles could have caused for the school. But they said that it was not offensive.
So in our situation, though, there actually was a disruption, correct? So we don't have to wonder would there have been a disruption, because there actually was a disruption. So explain to me how I can find that there wasn't a disruption when I think with the uncontested material facts are that there was a moment when that math class was no longer about math.
Right.
Right?
Yes. So, Your Honor, I think we need to think about whether or not it was substantial material disruption. So I would like to talk to you about the Winitsky case, where there was actual disruption. And in that case, the plaintiff, Aaron, had an I am icon which depicted a small drawing of a pistol firing a bullet at a person's head that had the words, "Kill Mr. Vandermolen," end quote. The United States Court of Appeals for the Second District upheld the district court's judgment that Aaron committed the act of threatening a teacher, which created an environment threatening the health, safety, and welfare of others, and his actions created a disruption to the school environment. Your Honor, this case contrasts to our case because my client, Elizabeth Stanton, did not cause a threatening the health, safety, and the welfare of other students. She was encouraging other students to assert their right of protest and protesting an anti-violent gun control. That's what she was doing. Although there was conversation, it was more so to encourage other students.
So are you saying that the message that she was trying to put out there is relevant to determining whether the disruption was substantial?
No, Your Honor. I would like to say it's a matter of whether or not the disruption was substantial.
And so how do I assess that? I mean, if I'm looking at Tinker was a silent protest, correct? So there's no noise that's disrupting a classroom down the hall. It's just people who are being silent. So how am I measuring substantial?
So in the case of Tinker, there was a classroom that was disrupted as well. And in Tinker, the court said that was not substantial. That was not substantial disruption. In addition, there are a number of other things that occur in the atrium, which is the loud noise that To the Record speaks of. And I would like to also point that loud things happen in the atrium all the time, such as school appellate group practices, pep rallies where cheerleaders, and singing. I would like to also point to the case of Hazelwood, where the court reasoned that if a public forum was conducted, then schools do not have the right to impose restrictions on school speech. If it is a public forum by policy or practice, such as a student organization. In our case, our client, Elizabeth Stanton, was a member of SAVE, which is a student organization, a school-sanctioned organization that frequently meets in the atrium. And
so are you saying that anything that SAVE did or that she did sort of under the umbrella of being a member of SAVE is permissible because the school can't infringe on her First Amendment rights if she's speaking as a public forum?
Well, that's according to Hazelwood. Yes, that is according to Hazelwood. That's what the court reasoned as a public forum. Yes. Okay. I would like to also point to another potential disruption in the case of Cuff v. Valley Central School District, where the United States Court of Appeals for the Second District concluded that the plaintiff's suspension should be upheld. In this case, the plaintiff drew an astronaut and expressed a desire to blow up the school with the teachers in it. The court reasoned that the threat of substantial disruption was aggravated by the student's wish, with fellow students and parents could reasonably view it as something other than the marketplace of ideas. I would like to also say that in Tinker, the court also says that the classroom is the marketplace of ideas, and schools are a good place for students to learn and have conversations. And as such, Tinker also says that students are not confined to just the classroom hours of exercising their constitutional right. They can do so in the cafeteria, on the playing field, or on the campus during authorized hours to express their opinions on controversial topics, such as, in the case of Tinker, the Vietnam War, without materially and substantially interfering with the requirements.
Does your argument require that this court determine that her shirt was not violent? And looking at the cases you cited regarding threats made to a teacher, right, or the Wisniewski case, I think it starts with a W, and cuff, which both have in them a threat to go to the school or to threaten a specific teacher. So is your argument that her shirt, even with the gun depicted on it, not a statement that includes any violence? And is that necessary for the court to determine to make its final ruling?
No, I would say not in the case of determining whether or not it's violent, because I think by nature seeing a gun on a shirt maybe, will raise some eyebrows, but I think it's more so to consider whether or not my client's anti-violence t-shirt, which is actually homemade, has the potential to cause substantial material disruption. So given the nature of the shirt, with the case law that I've supported with other similar factually situated cases, to show that even in those situations, courts have ruled that it was not enough substantial material disruption, except for in the case of the Winitsky, where there was actual disruption.
So let's talk for a minute about the school-sponsored pieces. Is your argument that this T-shirt was not school-sponsored?
This T-shirt was, I guess, in theory, school-sponsored, considering it is a part of my client's. It was made as part of my client's AP English presentation, which she conducted earlier that day.
And how does the court use the? Talk to me about and explain what school-sponsored means for the court's final ruling.
So school-sponsored would be something that the school has, I guess, encouraged to happen. So the teacher, the AP English teacher has encouraged the students to participate in a project on controversial topics. So that would be, school-sponsored. And then
and does that mean that where does the First Amendment law lie, and how does it change or what the school is able to do? How does that regulation change if it's school-sponsored or not school-sponsored?
I guess the regulation change as it relates to what is permissible for the client according to, because it's not really a violation if the student has authority or permission to wear the T-shirt as part of her AP English presentation.
Are there any school-sponsored cases that I can look to?
Yes, Hazelwood.
Okay.
Hazelwood is school-sponsored, and in that case, it was about a newspaper in regards to stories that, a newspaper article with stories that were about students who were pregnant, as well as students whose parents were recently divorced, and the school in that case thought that it was okay to censor school speech, and the court also ruled that it was okay for the school to censor it because it was school-sponsored. But that case contrasts to our case because the court said that the newspaper wasn't a public forum. In our case, we're saying that SAFE is a public forum because Hazelwood defined a public forum as one where students regularly meet and conduct activities. Thank you. So, Your Honor, may I briefly conclude? I figured the 1 minute is over. So for these reasons, Your Honor, we ask that you grant our motion for summary judgment. Thank you.
Thank you. Counsel, you may approach whenever you're ready.
Okay guys, so I am finished with my oral argument. It actually went really well. One of the key things that the attorney mentioned was that she said that she could notice that I was using my note cards a lot, so she was like, I had to pull you out of that by asking you questions early on, which I didn't actually mind, but yeah, it was actually really good, and I'm happy it's done and over with. Now I actually can go back to being a law student. But if you guys enjoyed this video, make sure you like, comment, subscribe, share it with someone that you think it will be helpful for, and I hope to see you guys in the next video. Bye!